And so remember, whenever you're talking about search and seizure, a lot of our clients say, well, I had an expired registration, but they pulled me over because they saw me coming from a place that's selling drugs. Pretext doesn't matter. There's no such, it doesn't matter that the officer had another reason why they did it, as long as there's a legit reason to do it. So if you have an expired registration and you know damn well they're pulling you over because you're coming from a drug house, we don't win because we say they didn't really pull me over for the expired registration. It doesn't matter. As long as they had the reason to, they win.
Absolutely. And I think it brings up a good point with the Gantt conversation that, you know, they can claim one exception and it not apply, but as long as some exception applies, it's likely that the search will be saved.
Well, that, and now they have like a good faith, you know, exception to where, you know, the officer. So what's been happening lately is there was this decision, I believe it was out of North Carolina, where the officer said he observed a violation, a traffic violation, and that gave him reasonable suspicion to stop. It turned out there was no traffic violation. And the courts have said, well, but in his head at that moment, he genuinely felt there was a traffic violation. That's good enough for us. I actually had that case cited against me recently where I had a video that showed my client did not commit a traffic violation. And, you know, the officer had this traffic violation listed in the report, and the video showed he didn't commit that. And the prosecutor says, well, here's this case out of the Supreme Court. You know, it's still something to be argued, but.
Right, because they still can't lie about it. It still has to be truthful. I mean, if they're lying about it, if they say you had a broken taillight and there's not a broken taillight, then we still may win that argument.
Right.
I understand what you're saying about that case, but I think we could still win that argument. You may feel differently.
No, I agree. I think the touchdown of the Fourth Amendment is reasonableness. It's unreasonable to say that a headlight or a taillight is busted when it is in fact not.
Yeah.